Yes, Your Lordship. I beg to mention item number 30. Your Lordship, I have the similar prayer for
Number
13.
13.
13.
You're for appellant.
Appellant, yes, Your Lordship. The conducting counsel, grandmother, is in ICU, Your Lordship.
On pre-made by the appellant, this is matter after 3 weeks.
Lordship.
May I please, Your Lordship? Item number 6, my lord, on daily list. The conducting counsel, Ashish Barua, his mother expired, so therefore he is in bereavement, my lord.
My lord, Mr. Barwa called me up. On the last few occasions, adjournment was paid on the ill health of the mother, my lord. So unfortunately, my lord, sadly, his mother passed away.
When?
My lord, last
4-5 days back.
I'm not sure.
Exactly, I'm
So
not 4-5. He's just on phone.
So
He is instructed.
he's performing the rituals and all, my lord. He's informed.
On pre-made by the petitioner, on grounds of personal difficulty,
On bereavement, my lord.
on the ground that the learned conducting counsel is in bereavement, the same not being objected to by respondent. This matter is adjourned. This is after 3 weeks.
Highly obliged.
My lord, I beg to mention item number 15, my lord, on behalf of state respondents. 15, my lord. This is a fresh case, my 2023 matter. My lord, the conducting counsel for the state is Mrs. Ailingwa. So, my lord, she has having personal difficulty. My lord.
No objection.
On pre-made by the state respondent, this is matter after 2 weeks.
Highly obliged, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention in item number 11. Lordship, I'm praying for some more accommodation, Your Lordship.
Therefore,
The appellant.
on pre-made by the appellant, this is matter after 3 weeks.
Obliged, Your Lordship.
From supplementary cost list, item number 1.
Your Lordship.
Yes.
Your Lordship, actually, since my senior counsel could not appearing before this court today, however, Your Lordship, since the matter is urgent, I would just like to brief the Honorable Court regarding the matter of the civil revision which we have filed. Your Lordship, this civil revision we have filed on behalf of the Umsao Kwan village, Dorbar, Your Lordship, who are the applicants in this present matter, Your Lordship. We are aggrieved by the order dated 15/6/2023, which is Annexure 1, passed by the Additional Deputy Commissioner, Your Lordship, cum District Judge Nongpor, in Miss Case number 2 of 2018, which is shown as Miss Case number 2 of 2022, whereby, Your Lordship, the Honorable Lower Appellate Court have condoned the delay of 707 days in preferring the appeal against the order passed by the trial court on 16 February 2016, whereby, Your Lordship, the brief fact of the matter, if it may please, I will just address this Honorable Court as follows, Your Lordship, based on this synopsis. Your Lordship, the money suit number 8 of 2014, praying for degree of realization of 8 crores with a compounding interest of 12% per annum, was filed by the plaintiff, State of Meghalaya, which is represented by the Department of Forest and Environment, against the defendant herein, the appellant, Your Lordship, or the applicant's Lordship, on the ground that a parcel of land measuring about 9,24,441 10 square kilometers situated at Maupalai village was acquired under the Land Acquisition Act 1894, herein after referred to as the Land Acquisition Act, Your Lordship, following the procedure prescribed by Section 4 to 17 of the said Act, Your Lordship. And the village Dorbar Umsao Kwan village, represented by the headman, was granted a total compensation of rupees 10 crores for the acquisition of the said land, and out of the said total compensation, 10 crores, an amount of rupees 8 crores was disbursed by the collector to the duly constituted attorney, who is the applicant number 2, attorney of the village, Your Lordship. On payment of the said 8 crores, Your Lordship, duly received by the appellants, urgent possession of land was taken over by the Government of Meghalaya in the Forest Department on 21st/6/2011 by way of check number so-and-so dated 21st/6/2011, Your Lordship. However, Your Lordship, the remaining amount of 2 crores was not paid disbursed in favour of the applicant being the landowner, Your Lordship. The applicant herein filed a petition, Your Lordship, being WPC number 275 of 2012 before the Shillong bench of the then Guwahati High Court, paying for mandate of payment of the said remaining 2 crores, Your Lordship. Upon receipt of the notice, the said proceeding of the Government of Meghalaya to the Deputy Commissioner of Ribhoi District, Your Lordship, sought to annul the entire land acquisition, Your Lordship. Proceeding forcing the present applicants being writ petitioners to file a second writ petition being WPC number 299 of 2012 before the High Court of Meghalaya, Lordship. Both the writ petitions were taken up for hearing, and by judgment and order dated 17/2/2014 passed in WPC number 299 of 2012, the following observation was made by the Honourable High Court, Your Lordship. I'll just gist the observation made by the Honourable High Court, Your Lordship, that the notice for intended annulment of the land acquisition passed by the Deputy Commissioner.
Is that on record?
It's on record, Lordship.
Which?
It's it's in the second paragraph.
What is the annexure? Tell me.
It's in this. Annexure 2/10. It is Annexure 2, Your Lordship, the appeal preferred by the state.
Page?
Page 68, Your Lordship.
You were reading the High Court's order.
No, Your Lordship, I'm just reading the gist, Your Lordship, just preferring. The High Court order is in the Annexure 212, Your Lordship. It has page 72 to 76, Your Lordship.
Yes, please continue.
Just this, Your Lordship. And hence both the notices were set aside, Your Lordship. Both the notices. So, Your Lordship, it was further observed that if the government was sure enough that the petitioner, who are the applicant herein, had taken the payment of rupees 8 crores by fraudulent practice, then they should file a recovery suit before the appropriate court, failing which the respondent government is directed to pay the remaining of rupees 2 crores as agreed upon by the parties at the time of acquisition, within 4 months from the date of receipt of the judgment and order, along with 9% interest and thereafter 12% for each day. With regards to this particular judgment and order passed by the Honourable High Court, Your Lordship, the money suit number 8 of 2014, Your Lordship, was filed by the State of Meghalaya, represented by the Forest Department and the Forest and the Environment Department, being the plaintiff against the humble applicants, being the defendant paying for recovery of 8 crores. The suit was filed in and around, Your Lordship, 13/6 of 2014. On receipt of the notice, Your Lordship, the defendant applicants before this present matter, he filed an application under Order 7 Rule 11 of CPC, Your Lordship, praying for rejection of the suit on the specific grounds enumerated in the said application to show a cause of action. The matter was being heard, Your Lordship, and was finally decided on 16/2/2016 by the learned of the Assistant to Deputy Commissioner, Learned Court Assistant Deputy Commissioner, Your Lordship, Ribhoi District, Ontario, holding that the suit was not maintainable, Your Lordship, in its present form, both for non-joiner parties of necessary parties as well as for one of cause of action, and being barred by law provided under the clauses of A and D of the Order 7 Rule 11, thus entailing rejection of the plaint. Although, Your Lordship, the order dated 16/2/2016 was passed after hearing submission of both the parties. An appeal against the order dated 16/2/2016 was preferred by the state, being the appellant before the court of the learned additional deputy commissioner, Nongpo, invoking the provision of Rule 36A 36A of the rules of 1937 after a delay of 707 days, Your Lordship. The said appeal registered was the regular first appeal number 1 of 2018 was accompanied by an application for condonation of delay being registered as missed case number 2 of 2018 without, however, disclosing any provision of law under which condonation of admitted delay was being sought. The applicant filed a show cause objection to the prayer of condonation of delay of 707 days, Your Lordship. However, Your Lordship, after hearing both parties, the Honorable Appellate Court was pleased to pass the order dated 15/6/2023, condoning the delay of 707 days by holding as follows, Your Lordship. This court find that the intention of the applicants was bona fide. There was no deliberate inaction on part of the applicant in taking up the matter, and they have not slept over for their right or waive it, and it shows that they are interested to pursue this matter. As such, this court finds in interest of justice the delay of 707 days is hereby condoned, Your Lordship. Your Lordship, that is what we are being aggrieved of, and Your Lordship, we are praying before this honorable court, since senior counsel, Your Lordship, is in the hospital. We would like to pray for just to stay this order, Your Lordship, as it has been
Who's
passed in
you are paying for the answer? Yes, what is your submission?
Lordship, the learned DSJ is on legs, Lordship, if this matter can be heard in his presence.
because the appeal for Your Lordship.
First, please. We'll take it at the end of the board.
Item number 2.
Yes.
My lord, this matter was heard and this hearing is concluded. My lord, it is fixed for filing the written synopsis by the petitioner. My lord, my lord, I am filing it by tomorrow. My lord, my lord, I am praying this matter can be reserved for judgment. My lord, we will file it by tomorrow. My lord.
File it then. File it by today. Why tomorrow?
My lord, I will try to file it in course of the day. My lord.
I will not pass any order as yet. So you file it in the course of the day, and then the matter will be. Otherwise, we'll fix it on a day when you are ready with your written argument.
My lord, it's almost ready. My lord, we will file it
Tomorrow.
My lord, fix it. My lord, may fix it tomorrow.
On prayer made by the petitioner, list this matter tomorrow.
Very costless. Item number 1.
Please, Your Lordship. Lord, there are 7 points that I want to deal, and those 7 points, I have the relevant judgments as well as the compilation to save Your Lordship's valuable time.
Before that, Mr. Shulai?
May it please Your Lordship. Lordship, the case there is in three volumes, Your Lordship, but I'll hand over to Lordship the first volume because I have sorted out the thing for issue reference by Your Lordship. I will not keep the second volume because
only what is necessary.
Yes, Your Lordship.
As far as this matter is concerned.
Also the gist of the gist of the progress of the investigation, Your Lordship. That I'll be handing over to Your Lordship.
Please, Your Lordship. If I may.
Thank you, sir.
My Lord, the first point is, I'm just stating the points and then I deal with them. The first point is that the accused persons were cooperating in response to section 4041 capital A of CRPC. They had gone there, they had cooperated, then again another notice was sent, and when they went, they were arrested. The judgments will indicate, my lord, that where a citizen has cooperated, there is no arrest. There is no need for arrest. And I'll place those judgments, my lord, when I come to judgments. That is the first question. The second question is that there is no such offence. The accused, my lord, there is no order which prohibits bail. This is a case where there are only bailable orders, and the bailable section 188, they are prosecuted on the basis of 188, which patently cannot be invoked. And the Supreme Court says that, well, this kind of disobedience, obfuscation, annoyance and injury, etc., is unfortunate in a situation like this. Citizens' right to liberty must be respected. But the third, I will deal with other sections also, which are only relatable to a bailable offence, and therefore they were bound to be released if they offer bail.
How many accused persons are there?
You are mentioning accused person, so he's confused. There is only one petitioner. There is only one petitioner.
Only one petitioner, my lord.
You are making a reference to they, meaning many.
The other people went, they were not arrested, so I'm not.
The other people went, anyway, I'll deal with that.
You restrict yourself to the petitioner, yeah?
Submission number 3 is that cooperation. They say that in the proceedings that they were not cooperating. They were summoned for appearance, were not cooperating. And the Supreme Court, in the case of Santosh, says that cooperation doesn't mean confession. Cooperation means that you summon and they come and appear. Whatever is within their knowledge, that is stated. But to say that not cooperating, despite the fact that 2 consecutive days when they were summoned, they were there. And my lord, fourth point is that bail ought to have been given when they appeared under 441A, and the police in its diary is supposed to record the statement and determine as to what will. Then, my lord, the next is with regard to vicarious liability. On the basis of vicarious liability, the accused have already been handed over possession of the factory, and therefore this is not a case where the dispute between the co-owners was sought to be resolved one way or the other, and the physical possession is handed over, agreements are entered into, and then this bail is denied.
Let us go first to the.
Yes,
let us go to the FIR first.
Pardon, my lord?
Let us go to the FIR. What does the FIR say?
FIR has not been enclosed, Your Lordship, most probably.
You want to read the FIR?
FIR is not there, Your Lordship.
So page 24.
Huh?
Page 24.
24.
Well, this is unreadable.
Should have got it typed.
I think the state was directed to produce the record, the case diary.
No, this is not there. This is not the FIR, Your Lordship.
I can't read it.
FIR number 39-2,
No, this is not FIR.
Lords may come to page 20.
If you had filed, you see, if you are filing a bail application, invariably the FIR should have been there.
That is there. If Lords may come to page 22.
It's a gross case.
22.
Page 22, if Lords may have.
This is not the. This is,
So this is FIR number 39.
This is the format.
Yes.
But
And now if
where
Lords
is-
may come to page 24. So it says, further received from so-and-so,
Yes.
white so-and-so, the original FIR is forwarded to Honorable Court of Special Judge MMDR Act, non-stop through PI non-stop.
You should have got a copy of the FIR.
FIR is not there.
So this is what we have, Lords. Lords, we have, Lords, my instructions are that we have not been furnished with the copy of the FIR.
Come on.
But when you were arrested,
Yes.
see, the moment you were arrested, you should have made an inquiry as to how you have been arrested, on what basis you've been arrested. Obviously, it would be on the basis of a FIR.
Yes, Lords.
So to that extent, if you are, coming before the court, you should have prepared yourself. And
Lords, the FIR remains the same. Lords, Lords, I will request if my Lordship may please come to the impugned order. Because I think the much water has flown. I was arrested, I filed for bail. The allegations will emerge out from there only, Lords. At page 42, annexure 9.
Well, two other points which arise, if your lordships permit, is that when there are counter cases or cross cases, bail is to be granted.
that, we are not on that. We are not on that. That will come later.
I will.
But let's get
I'll
first-
place those judgments.
but
That's the point I'm only indicating.
First, let's get to the basics. Let's get to the basics and see.
Yes. And the last point is that offences, if the offences are compoundable by the statute, then bail has to be granted.
I'm saying that we will come to that. Let us see what is your basis for coming for this court.
Page 42 onwards.
This is also an order. You have a copy of the you have FIR with you?
Lordship, yes, I do have. It is here in this case diary, Your Lordship. That I'll place, Your Lordship.
Show me that, please.
I thought there was a direction to have it at the court.
I'll just keep this piece only, Your Lordship, then I'll get,
Whatever.
because it's...
So you don't even know what is the allegation against you? You don't have a copy of the FIR with you?
I think he's referring to this page.
Your lordships are referring to page
No, this one with the reference to.
with reference to subject cited above and in compliance with the order issued by the Deputy Commissioner, West Khasi Hills District, Nongston.
Yes, this is the one.
Yes. So there are no allegations against us in this.
And the sections which are being invoked are not made out, or they are all bailable. They are all bailable, my lord.
That remains to be seen.
First is section 188. 188, what is said is, whoever knowing, if your lordships, my lord, I have handed over compilation. This is page 2 of, first is the list of dates of page 2. Section 188.
Just a moment.
Lord, Section 188, disobedience to the order of duly promulgated by public servant.
Just a moment. Page 2.
Page 2.
No, it's not. He's going to the numbered.
You're referring from the compilation?
Not the numbered pages, just the second page of the compilation. I'm very sorry.
There's no pagination here.
Yeah, this second page, sir. It starts with grounds.
This is only with regard to the sections and whether they are available.
Yes, please.
188. Whoever, knowing that by order promulgated by the public servant, lawfully empowered to promulgate such order, he is directed to abstain from a certain act or take certain order with certain property in his possession or under his management, disobeys such direction. Now, my lord, this is obviously an offence which is punishable with less than 7 years. And shall, if your lordship may come to the right hand column, if such disobedience causes or tends to cause obstruction or annoyance or injury or risk of obstruction, annoyance or injury to any of the lawfully employed, be punished with a simple imprisonment for a term which may extend to 1 month. The only question was that, am I ready to give bail? And if I am ready to give bail, I will get bail as of right. That's the law. I will place that law also, but let me place these other sections which are invoked. My lord, penalty for contravention, punishment for theft. Penalty for contravention of the provisions of the Act, that is Environmental Protection Act. Whoever fails to comply with the contravention of the provisions of this Act or the rules made thereunder or directions issued thereunder shall, in respect of each such failure or contravention, be punishable with imprisonment for a term which may last 5 years, less than 7 years. Less than 7 years is bailable offence. 1 lakh so and so, or contravention continues, the additional fine may have to be extended from 5,000 to 5,000 rupees for every day during which the failure of contravention continues, but they do not have the power to take the particular offence, the manner in which it has been committed, out of the CRPC and disobey the mandate of the law. Mandate of the law is less than 7 years, bailable offence. Then, my lord, third, penalty for the third is punishment for causing explosion likely to endanger life or property.
This is explosive acts. This is explosive act.
This is explosives act.
And there is no recovery from me.
And there is no recovery, my lord. There is no recovery. And penalties under this in any case.
No, this is now mine and mineral.
This is Mines and Minerals Development and Regulation Act 1957, penalties. Whoever contravenes the provisions of subsection 1 or section 1 capital A of section 4 shall be punishable with imprisonment for a term which may extend to 5 years. And this is, my lord, further reduced to 2 years. 2. Any rule made under the provision of this Act may provide that any contravention thereof shall be punishable with imprisonment for a term which may extend to 2 years, or with fine, or with may extended by 5 lakh rupees. So therefore, my lord, the offences are less than 7 years and maybe even less than 2 years. But 2 years is good enough, that's a bailable offence. So, my lord, the principle which is laid down by the Supreme Court with regard to this provision, your lordships will see, my lord, section 41 capital A. They are dealing with 41 capital A. 41A compliance done. I had also done the compliance.
Yes.
They summoned me, I went there. No need to arrest. That's what the Supreme Court says. I'll be reading the relevant part of the judgment, my lord. For arrest to be recorded in writing, reasons for arrest to be recorded in writing, accused complying.
Are you reading section 41A or just a reference?
Just a reference. He's asking if we are reading the section, we are just making a reference right now. We'll read the section.
Very well. This is, my lord, page 9 of the compilation. Arnesh Kumar. Page 9 of the compilation. Okay. Let's keep on now. Page 9, 11 by 11.4.
First give the citation, then go to the paragraph.
14A, my lord, on page 8.
So citation is 2014 8 SCC 273. Arnesh Kumar.
This is Arnesh Kumar. Your lordship may kindly see, my lord, page.
Just a moment. You are referring to para
11, where the conclusions are drawn, and I am really reading up from 11.2, 11.3 to 12.
Please.
11.4, my lord. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. I am not in a position to make a statement whether this was done or not, but when the case diary is placed before your lordships will read, my lord. I am not entitled to it till the charge sheet is filed. 11.5. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks. 11.6. Notice of appearance in terms of section 41 capital A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. I don't know whether these compliances have been made, but your lordships will see, my lord. If it is, I'm sure your lordships will give us the benefit. Then 11.7. Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental inquiry, they shall also be liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. Such is the importance which the Supreme Court grants to timely action and timely situation. And then my lord, 11.8, authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by appropriate High Court.
We have to read this because it says less than 7 years over here. So this is where we are relying upon.
Then my lord, para 12. We hasten to add that the directions aforesaid shall not only apply to a case under 498A IPC or Section 4 of the Dowry Prohibition Act, the case in hand, but also such cases where offences are punishable with imprisonment for a term which may be less than 7 years.
Case is also less than 7 years.
And the entire schedule of timing, how much time will be allowed, is granted. Then, my lord,
Cases also, all sections are less than 7 years.
all right. The second point which I wanted to place before your lordships, page 9, हो गया, 98 है. Page 43, your lordship may kindly come to. Forty 43, para 23. Well, before that, 60, section 60, capital A has been referred to. I'll just read that. Yeah. This is, my lord, citation your lordship will get from the paging itself.
It would be proper for you first. It would be proper for you to first give the citation, then the relevant portion that you are relying on.
Your lordship, my lord, page 43, section 23, section 60, capital A. Citation is 2022, 10 Supreme Court cases, page 51. Arrest to be made, yes. Section 60, capital A of CRPC, which is being quoted in after 22, my lord. 23. Yes. 20 is capital A. Arrest to be made strictly according to code. No arrest shall be made except in accordance with the provisions of this code or any other law for the time being enforced, providing for arrest. Then para 23. Section 41 under chapter 5 of the code deals with the arrest of persons. Even for a cognizable offence, the arrest is not mandatory, as can be seen from the mandate of the provision. If the officer is satisfied that the person has committed a cognizable offence, punishment with imprisonment for a term which may be less than 7 years, or which may extend to the said period, with or without fine, an arrest could only follow when he is satisfied that there is reason to believe or suspect that the said person has committed an offence, and there is necessity for an arrest. Such necessity is drawn to prevent the committing of any further offence for the purpose of investigation and to prevent him from doing such disappearance or tampering with evidence. He or she can also be arrested to prevent such person from making any inducement, threat or promise to any such person according to the facts, so as to dissuade them from disclosing said facts either to the court or to the police officer, One more ground on which the arrest may be necessary is that his or her presence is required for arrest for production before the court, and the same cannot be ensured. Para 24, my lord. The provision mandates the police officer to record his reasons in writing while making the arrest. Thus, a police officer is duty-bound to record the reasons for arrest in writing. Similarly, the police officer shall also record when he or she chooses not to arrest. There is no requirement of the aforesaid procedure when the offences alleged is more than 7 years, amongst others. Para 25, my lord. The consequences of non-compliance of Section 41 shall certainly injure to the benefit of the person suspected of the offence. Resultantly, while considering the application for enlargement on bail, the courts will have to satisfy themselves on the due compliance with the provision. Any non-compliance would entitle the accused to a grant of bail. My lord, I wanted to place Santosh's judgment at page 101, 98 to 101.
1 second, page 87 first. Page 87. Let's read category A. Category A and B.
A and B. Page 87, my lord, your lordship may find it here.
87.
First 87, then I read the other pages. Categories A and B. This is placitum B.
Yes.
We have already dealt with the relevant provisions which would take care of categories A and B. At the cost of repetition, we wish to state that in category A, one would expect better exercise of discretion on the part of the court in favor of the accused. Coming to category B, these cases will have to be dealt with from case to case basis again, keeping in view the general principle of law that the provisions as discussed by us.
We are in category A. Our case is in category A.
Hold on. And one Santosh.
Now we are reading Santosh. You have to give citation.
Yes. Page 98, my lord. Santosh, with regard to that cooperation doesn't mean being forced to make a confession.
Ninety-eight it starts, we have to read 101. 98 it starts, we have to read 101.
Para 6, my lord, at page 101.
Yes.
Placitum B. The IO was of the opinion. The IO was of the opinion that the appellant was not cooperating because he kept reiterating that he had not purchased the food grain. The purpose of custodial interrogation is not just for the purpose of confession. The right against self-incrimination is provided for in Article 20 Clause 3 of the Constitution. It is a well-settled position in view of the Constitution bench in Selvi that Article 20 Clause 3 enjoys exalted status. This provision is an essential safeguard in criminal procedure and is also meant to be a vital safeguard against torture and other coercive measures used by investigating authorities. Therefore, merely because the appellant did not confess, it cannot be said that the appellant was not cooperating. And my lord, the previous day when they called me, I went. I answered the questions. There was no grievance against me. But second time, the next very day, they again summoned. Again I went, and they make a contradictory order of arrest.
Sanjay Chandra, page 124. Sanjay Chandra, page 124.
Yes, my lord, bail is a rule. That is Sanjay Chandra and also P. Chidambaram. Page
124.
Para 39.
Page?
Page 124, para 39.
So citation is 2012 1 SEC, page 40. It starts from page 102.
Yes.
Yes. Notes. May kindly come to page 124, the relevant portion.
Section 39. Coming back to the facts of the present case, both the courts have refused the request for grant of bail on two grounds. The primary ground is that the offence alleged against the accused is very serious, involving deep-rooted planning in which huge financial loss is caused to the state exchequer. The secondary ground is that the possibility of the accused person tampering with the witnesses. In the present case, the charge is that of cheating, dishonesty, inducing delivery of property, forgery for the purpose of cheating, using genuine as a forged document. The punishment for offence is imprisonment for a term which may extend to 7 years. It is no doubt true that the nature of the charge may be relevant, but at the same time punishment to which the party may be liable to be convicted, if convicted, would also bear on the issue. Therefore, determining whether to grant bail, both seriousness of the charge and severity of punishment should be taken into consideration. The grant or refusal to grant bail lies within the discretion of the court. The grant or denial is regulated to a large extent by the facts and circumstances of each particular case, but at the same time, right to bail is not to be denied merely because the sentiments of the community against the accused. The primary purpose of the bail in criminal cases are to relieve the accused of imprisonment, to relieve the state of the burden of keeping him pending the trial, and also at the same time to keep the accused constructively in the custody of the court, whether before or after the conviction, to assure that he will submit to the jurisdiction of the court. Twice I have appeared, and then they have no reason to say that I will not appear. I have appeared. Para 46, my lord, of the same. We are conscious of the fact. We are conscious of the fact that the accused are charged with economic offences of huge magnitude. We are also conscious of the fact that the offences alleged, if proved, will jeopardize the economy of the country. At the same time, we cannot lose sight of the fact that investigating agency has already completed investigation and the charge sheet is already filed before Special Judge CBI Delhi. Therefore, the presence in the custody may not be necessary for any further investigation. We are of the view that the appellants are entitled to grant a bail pending trial on stringent conditions in order to allay the apprehensions expressed by the CBI. Your Lordship will see, my Lord, Mr. P. Chidambaram's Criminal Appeal number 1831 of 2019.
Page?
Page 128, my lord. It starts at 128. Citation is 2019 SCC online 1549.
Yes.
We are reading at paragraph 14. Yes. Lord, I'm reading from page 133.
Please.
Para 14. The learned senior counsel for the appellant, in reply to the submissions, contended that not a single document is available to indicate that the appellant is involved in the offences. The allegation of appellant tampering with evidence or influencing witnesses as sought to be made out on behalf of the respondent cannot be accepted, for the reason that the alleged offence is of the year 2007-8, and though the proceedings were initiated in 2017, the appellant was arrested only in the year 2019. In such event, when the appellant has not influenced any person while he was at large, the allegation of tampering while in custody is not acceptable. The statement of the alleged witnesses is stated to have been recorded in the year 2018, and the case of the respondent that they are seeking to confront witnesses is being put forth at this stage only to indicate that the custody of appellant is still required by them, when there is no document to indicate that the appellant is involved. The mere allegation that the alleged co-conspirators cannot be said to be the basis to indicate that the economic offences has been committed. Then below para 16, there is a triple test which is laid down. Triple test is para 16. I just read first 3 lines. In the above background, perusal of order dated 15th November 2017, impugned here, indicates that the learned single judge, having taken note of the rival contentions, in so far as triple test for triple test or triple test to be applied while considering the application for grant of regular bail under 439, has answered the same in paragraph 50 to 53 of the order in favor of the appellant herein. So, the triple test is
Prima facie case. Triple test is prima facie case.
prima facie case,
Against the accused.
and triple test is that he's not a fly bird, not likely to evade the.
Tamper with evidence. Or tamper with evidence. Tamper with evidence.
No recoveries.
No tamper with evidence.
Oh, that's right. Tamper with evidence, I've said. Page 134, para 16, but this is 7th line from top. With regard to the witnesses having written that he is not prepared to be confronted, as he is from the same state, the appellant cannot be held responsible for the same, as there is no material to indicate that the appellant or anyone on his behalf has restrained or threatened the concerned witness who refused to be confronted with the appellant in custody. So they have to have some document, otherwise it's just an oral thing. Page 23, para 23 at the next page, page 135. Thus, from the cumulative perusal of the judgments cited on either side, including one rendered by the Constitution Bench itself, it could be deduced that the basic jurisprudence with regard to bail remains the same, inasmuch as the grant of bail is the rule and refusal the exception, so as to ensure that the accused has the opportunity of securing fair trial. However, while considering the same, The gravity of the offence is an aspect which is required to be kept in view. The gravity for the said purpose will have to be gathered from the facts and circumstances of the case. Then, my lord, para 24. Para 24. In the above circumstances, it would be clear that even after concluding the triple test in favor of the appellant, the learned judge of the High Court was certainly justified in adverting to the issue relating to gravity of the offence. However, we disapprove the manner in which the conclusions are drawn in paragraph 57 to 62.
Sunil Bharti Mittal. 68, sir. Sunil Bharti Mittal.
Then, my lord, page 137, para 26. Having said so, having said, the court has many a times been handed over by the investigation sealed covers. This is their expressing their view on sealed covers, because the courts have refused to accept sealed covers. Having said so, in the present circumstances, we are not very much inclined to open the sealed cover, although the materials in the sealed cover were received from the respondent. However, since the learned single judge of the High Court had perused the documents in sealed cover and arrived at certain conclusion, and since the order is under challenge, it had become imperative for us to open the sealed cover and peruse the contents thereof to justify ourselves to the extent on the perusal we have taken note of the statements of the persons concerned have been recorded, and the details of this nature of the allegation against one of the co-accused, Karti Chidambaram, son of appellant, of opening shell companies and purchasing Benami properties in the name of relatives and other persons in different countries. Except for recording the same, we do not wish to advert to any of the documents for any further since ultimately these are allegations which could have been established in the trial during the accused or co-accused would have the opportunity of putting forth in their case. And my lord, slightly below the middle, as recorded, as noted, this is at page 37, about 10th or 11th line from para 27.
Yes.
As noted above, the appellant has not been named in any of the accused by any of the accused in the ECIR, but the allegation while being made against the co-accused is indicated that the appellant, who was the finance minister at that point of time, aided the illegal transaction. Since one of the co-accused is son of the appellant, in this context, even if the statements on record and materials gathered are taken note of, the complicity of the appellant will have to be established in the trial, and if convicted, the appellant will undergo sentence. For the present, as taken note of, the anticipatory bail had been declined earlier, and the appellant was available for custodial interrogation for more than 45 days. In addition to the custodial interrogation, if further evidence is to be made, the appellant would be bound to participate in such investigation as is required by the respondent. Further, it is noticed that one of the co-accused has been granted bail by the High Court, while the other co-accused is enjoying interim protection from the arrest. The appellant is aged 74 years and is noted by the High Court itself that its order in its order that the appellant has already suffered 2 bouts of illness during the incarceration and was put on antibiotics and has been advised to take steroids of the maximum strength. For this circumstance, the availability of the appellant for further investigation, interrogation, and is facing trial is not jeopardized, and he is held to be not a flight risk, and there is no possibility of tampering with evidence nor influencing or intimidating witnesses. Taking these and all other facts, the circumstances, including the duration of custody, into consideration, the appellant, in our considered view, is entitled to be granted bail. Then, this is 2015 4 SEC.
What is that?
Next judgment, my lord, that's also a three judge bench. 2015 volume 4 SEC 609, and I am placing before your lordship page 168, para 42. No doubt, a corporate body is an artificial person which acts through its officers, directors, managing directors, chairmen. If such company commits an offence involving mens rea, it would normally be the intent and the action of that individual who would act on behalf of the company. It would be more so when the criminal act is that of conspiracy. However, at the same time, it is cardinal principle of criminal jurisprudence that there is no vicarious liability unless the statute specially provides so. Thus, an individual who has perpetrated the commission of an offence on behalf of the company can be made an accused along with the company if there is sufficient evidence of his active role coupled with criminal intent. Second situation in which he can be implicated is those cases where statutory regime itself attracts the doctrine of vicarious liability by specifically incorporating such a provision. Para 44. When the company is an offender, vicarious liability of the directors cannot be imputed automatically. In the absence of the statutory provisions to this effect, one such example is section 141 of the Negotiable
What do you want to
Instruments
say
Act.
here? What do you want to point out from this?
Even if I am the managing director, I cannot be held responsible.
No, directors, unless they are shown to have taken active part, then they will not be.
So the accused is a director.
Yeah.
So they allege that I am the director of the managing director of the.
Yeah, I'm only placing the law as interpreted by the lordship.
But it has to be relevant to the fact situation.
Yes.
Please continue.
Well, there are 2 more judgments.
They allege I am the managing director of this company. However, by this document, I have already given possession.
My lord, the petitioner was a director in the company.
Is the director.
Thereafter, he has handed over charge. He is no longer a director.
No, he's still the director. He's still the director, but the factory is handed over. A company.
Company has been handed over. He would still continue to enjoy the status of a director, but his individual role has not been put on record. So that is why, my lord, this judgment. My lord, page 180, 181. 181. This is, my lord, just a paragraph, half a paragraph.
What page?
Page 176. The judgment starts: State of MP versus Mishri Lal, 2003, 9 SCC 426.
And I'm reading para 8. Fifth line from bottom, from top.
2003, 9 SCC 426.
Paragraph?
Para 8, sir.
Yes.
Para 8, my lord, the line starting with guidelines devised by this court. First word is guidelines.
Where is it?
Guidelines devised by this court in Nathilal's case. The cross cases should be tried together. There are cross cases here.
Yes.
It's a different matter. They like to trouble only one party, not the second. But if the truth emerges, God knows who will be responsible. But in any case, the court is to conduct the trial one after the other. The evidence will also be recorded one after the other. And if there is a cross case and this procedure is not adopted, then it's a ground for setting aside the judgment. So here, my lord, the cross case should be tried together. Cross cases should be tried together by the same court, irrespective of the nature of offence involved. The rationale behind this is to avoid conflicting judgments over the same incident, because if cross cases are allowed to be tried by two courts separately, there is likelihood of conflicting judgments. In the instant case, the investigating officer submitted the challan against both the parties. Both the complaints cannot be said to be right. Either one of them must be false. In such a situation, legal obligation is cast on the investigating officer to make such a situation, to make an endeavor to find out the truth and cull out the truth from the falsehood. Otherwise, the trial will not start.
Nathilal, page 188. This is the citation.
This is, my lord, 1990s supplement SCC, page 145.
That's page 188.
This is page 188 of my compilation. There is a short order, my lord.
Yes.
Special leave granted, heard both sides. We think that the fair procedure to adopt in a matter like the present, where there are cross cases, is to direct the same learned judge must try both cross cases one after the other. After the recording of evidence in one case is completed, he must hear the arguments, but he must reserve the judgment. Thereafter, he must proceed to hear the cross case, and after recording all evidence, he must hear the arguments but reserve the judgment in that case. The same learned judge must thereafter dispose of the matters by two separate judgments. In deciding each of these cases, he can rely on the evidence recorded in that particular case. The evidence recorded in the cross case cannot be looked into.
What is the relevance of this?
Relevance, my lord? In this case, there are cross cases,
there are cross
counter
cases.
and therefore they thought that I can be dealt with the manner, but there is another party,
Okay.
and they have to adopt that. Anything else?
Then D. Shivakumar, that offense which are bailable.
Lord, page 195 of the compilation. This is the last judgment.
Citation is 2019 SEC Online Daily 10691 at page 190. It starts.
Lord, para 34.
Fixing, sir.
Para 34.
34. It is also not in dispute that the offences under section 276C and 277 of the Income Tax Act alleged against the petitioner are compoundable. Any offence, my lord, which is compoundable, there will be no custody. That's the spirit of the law. It is also not in dispute that the offences under section 276C, 277 of the income tax alleged against a petitioner are compoundable offences, and the only scheduled offence invoked against the petitioner is section 120B. Here also 120B. It is also not in dispute that Anjanya Hanumanthaya, who challenged orders of the High Court of Karnataka in writ petition so and so, wherein the Honorable Supreme Court issued notice and the Honorable Court directed the respondents that no coercive steps should be taken. No coercive court issued notice, and the Honorable Court directed the respondents that no coercive action should be taken against the petitioners. However, I am not giving any opinion on the merits of the case of the prosecution. Then we are at 36. While dealing with the bail application, it is not in dispute that three factors have to be seen. That is, flight risk, tempering evidence, or influencing witnesses. Because the purpose of bail, bail is perhaps 1,000-year-old. The purpose of bail is to ensure that he will attend the court and he will not go away. That's all that was required, and by normal conduct of human nature is that if he has gone yesterday, he will go today, believing them that, well, this is not going to jeopardize. But whatever it is, these kind of tricks the police is used to playing. Regarding tempering of the evidence, it is not in dispute that the documents relating to the present case is in the custody of prosecuting agency, Government of India and the court. Moreover, presently the petitioner is not in power except he is a member of the Legislative Assembly. Therefore, in my considered view, there is no chance of petitioner to temper with the evidence. Lord, my submission is that on various counts, the petitioner before your lordships deserves liberty to be restored. I'll fulfill all those conditions that may be laid down by your lordship or the court which is directed to. But this is a case where the conscience pricks. I am extremely grateful, my lord, to your lordships for giving me this time. I am very grateful to my learned friends and Pallavi Malhotra. I express my gratitude to them. Thank you, my lord.
This is your lordship.
Yes.
Lordship, if I may take back the copy of the FIR which I had done over to lordship. mean, this is your lordship. Lordship, can you see in this case, your lordship? There is an order passed by the full bench of this honor, by a division bench of this honorable court. That is the order dated 16/12/2022, your lordship. Your lordship, because in the case diary, your lordship, it is not, it cannot be read, your lordship. That's why I have taken out there.
Okay.
You are aware?
No, no.
Moni Kumar. Lordship, kindly see the order dated 16/12/2022.
Give them a copy.
Lordship, I don't have a copy.
If you are referring to any document or any authority, you should not take them as a surprise.
I can read from Lordship. That is the order dated 16/12/2022, your lordship, passed by this by the division bench of this honorable court, your lordship. Then, lordship, I'll come straight to the next page, your lordship. Next page toward the bottom, your lordship.
Yes.
According to a document issued by the Meghalaya State Pollution Control Board and relied upon in the writ petition, which is corroborated by the only 4 units. Karbusha, so your lordship, have consent to operate coke plant in the West Khasil district. All other cokes, whatever may be the size and whatever may be directly or indirectly controlling the same, must be shut down as of today. The Chief Secretary will file a compliance report with the Registrar General by December 19, 2022, confirming such position. The Deputy Commissioner of West Khasil, along with the Superintendent of Police, will show cause why appropriate action should be taken against such person for failing to take step against all coke units operating without the due authority. All Deputy Commissioner and Superintendent of Police in other states shall ensure that units cooperating within jurisdiction without due consent to operate. All Deputy Commissioner, District Superintendent of Police will confirm such position and for those units who have been found to have obtained illegally all materials and finished product and should be seized and immediately appropriate action against the person in control of the unit in accordance with law. So on the basis of this, your lordship, what happened? The Deputy Commissioner, your lordship. The Deputy Commissioner, your lordship, by the office order dated 16/12 December 2022, your lordship, which is part of the case diary, your lordship, directed the informant herein, your lordship.
Order digit?
Lordship, that is the order dated 16/12 December. Give me the flag mark.
Yes, yes.
Flag mark.
So on the basis of this order,
your lordship,
so what happened?
The informant, your lordship, the informant was directed to take immediate step to shut down all illegal coke operating in West Khasil district.
Yes.
Lordship, I'm flag marking it. Then your lordship, was a read was conducted now. That's why the FIR was lodged, your lordship.
Yes.
Lordship, can you see in this case, your lordship, 57 illegal coke plant were involved, your lordship, and the investigation of the case is going on, your lordship. Raid have been conducted, your lordship, by the police, and most of the people are hiding, your lordship. Your lordship, and so far the police had arrested 6 people, including the bail applicant here in your lordship. So far the registration of this case, your lordship, because a contention has been made that these are compoundable. Your lordship will kindly see it is a case registered under section 188, 34, 379, 120, read with section 21(1) of the Mine and Mineral Development Regulation Act, read with section 15.
Just please.
Lordship, I'm handing over, Your Lordship. It is already there, Your Lordship. Section 15, Environment Protection Act, Section 3, explosive.
Have you flag marked them?
Yes, Your Lordship. It's part of the report, Your Lordship. It's part of the report, Your Lordship. Kindly see, Your Lordship, Section 15, Section 3, Section 21 of the MMDR Act, Your Lordship. This is punishment is extended to 2 years. Then Section 15 of the Environment Protection Act 1986, Your Lordship. These are the imprisonment which may extend to 5 years or with fine. And Section 3 of the Explosive Substances Act 1908, Your Lordship. This will go even life imprisonment, Your Lordship. Then, so far, the arrest of the petitioner, Your Lordship, the guidelines issued by the Honorable Supreme Court in DK Bas case, Your Lordship, that has been fully complied with, Your Lordship. His mother has been informed, Your Lordship. The ground of arrest has been informed, Your Lordship. Everything is here in the case there. Everything is there in the case here, in the case there, Your Lordship. Then, so far, the argument has been canvassed regarding Section 41, Your Lordship. In my humble and respectful submission, Your Lordship, the police have followed the mandates of the CRPC, Your Lordship, in principle, Your Lordship, in toto, Your Lordship. Why the bail applicant has been arrested, Your Lordship? Lordship, that reason, Your Lordship, has been recorded by the IO, which is also, Your Lordship, has been made part and parcel of this bail application. If Lordship kindly come to page 39. Page 39, Your Lordship. Lordship, kindly turn to page 40.
Page 40.
Lordship, kindly come to page 39, Your Lordship. This is the a report submitted by the investigating officer, Your Lordship, for custody of the bail applicant here in Your Lordship before the special judge, MMDR, Your Lordship, no Spain. Lordship, here, Your Lordship, we are concerned with Kalyani Fuel Limited, Your Lordship. Before I refer, Your Lordship, let me submit, Your Lordship, that Kalyani Fuel Limited, Your Lordship, does not have the single window agency, Your Lordship. That has been, they have made an application that has been rejected. Lordship, everything is here. Everything is here. I flag mine. They don't even have the consent to operate, Your Lordship, and the consent to establish, as well as the consent to operate as required by the environmental law, Your Lordship. Lordship is aware of that Coke plan, Jem Coke, Your Lordship, where Your Lordship is part of the bench which dismissed that writ petition, Your Lordship. Then, Lordship, kindly come back to 39. Lordship, towards the bottom, whereas.
Yes.
Whereas a notice under Section 41A CRPC is issued to the below noted accused person on so-and-so during inquiring his attendance on so-and-so for his examination. And whereas the same has appeared before the undersigned on the date and time as specified in the same notice and subsequently on 15/6. This was the date of his second appearance before the IO, Your Lordship. Second notice under 41A, as required of him. Notwithstanding the above, the said accused person does not fully satisfy the condition of notice under Section 41A CRPC that he is made aware of and which are explained below. Given the above, his arrest is necessary in the best interest of the case for pressing reason. I am pleased to further elaborate as follows. To prevent him from committing further offence, that the bound of notice under so-and-so will not guarantee the below noted accused from committing further offence when investigation revealed that he is a habitual offender and is an accused person in other cases as follows. Lordship, the one case has been stated by the Honorable Kawati High Court, Your Lordship. Then kindly come to, Your Lordship. To prevent the accused person from causing the disappearance of evidence, that the evidence having a bearing on the case and pending search and collection pertain to plethora of documentary evidence involving tax invoices of the company owned by the accused person and lodged in its premises at the disposal of the employees who are by common sense under the mastery and influence of the accused person. The document pertain with the procuring of 2,000 metric ton of coal of MS Kalyani, the legality of which has to be examined. Lordship, all this reason,
these documents are being introduced now.
No, I'm sorry.
Yes,
I'm sorry, sir. I'm sorry to submit that these are part and
These are your-
parcel of your bail application. It is part of the annexure at page 39, Your Lordship.
This is your own. This is your own
This is
application.
your own document, sir. Your own document. I'm not giving a.
No, sorry.
It's all right. So these are the reason, Your Lordship. These are the reason, Your Lordship. These are the reason why arrest is necessary, Your Lordship. These are the reason, Your Lordship, which the IO has given is just in the report submitted before the court, Your Lordship. That also, this also is here in part and parcel of the case diary, Your Lordship. Lordship, that guideline of the DK Basu case, Your Lordship, that is 1997 1 SCC 416, Your Lordship. Lordship is aware of this. I need not burden your Lordship with this judgment, Your Lordship. Your Lordship is aware of this judgment, Your Lordship. The guidelines, Your Lordship.
Yes.
Lordship, that is in paragraph 29, Your Lordship, of that. Paragraph 29, Your Lordship. Lordship. So, Your Lordship, his arrest has been made, Your Lordship, keeping in view, Your Lordship, the guidelines issued by the Honorable Supreme Court in DK Basu case, Your Lordship. And also, Your Lordship, the mandate of section 41, Your Lordship. So my humble and respectful submission, Your Lordship, in view of the fact that the investigation is going on, Your Lordship, I am not going to disclose from the case diary, Your Lordship. The investigation is going on, Your Lordship, and a number of people, Your Lordship, they are under scanner and they are being hunted, being raided, Your Lordship, and Your Lordship, is too soon, Your Lordship. Considering, Your Lordship, the order passed by the division bench of this court, where Your Lordship also is part of the bench, Your Lordship. In my humble and respectful submission, Your Lordship, it's not a fit case for grant of bail at this moment, Your Lordship. At this moment. That is my submission.
So about the parties?
Lordship,
Lords, with my Lord's kind permission, Lords, with regard to the factual aspect, but Lords, see, my senior has argued, Lords, if I can just give certain points with regard to the factual aspect only, not on legal aspect, only on factual aspect, Lords.
Factual aspect you have already.
Lords, a few points which, Lords, I think, Lords, were missed out, Lords, with the due permission of the court. Now, if my Lords may kindly please come to page 39. Because much emphasis have been given on page 39, which is the forwarding application for the remand. Lords, may please kindly note the date. This is now 16th June 2023.
Yes.
Lords, it is said that on 16th June, my custody is required. Now, my Lords, today, my Lords, much water has flown. Lords, as per me, 35 days have gone. And now please turn over the page, my Lords.
When were you arrested?
15th of June, my Lords. 15th I was arrested, 16th I was produced. So all I am saying is, my Lords, much water has flown now today. Now 35 days have gone. The reasons which are now stated to show that yes, why my custody is required, that was material maybe. I am saying maybe it might be material at that point of time, but not today.
That would see the
Yes.
the-
Now,
the-
now,
the-
Milords. No, no.
the investigation will.
Yes. Now, Milords, may please come to page 40, because Milords, the facts are not. That's my submission, Milords. The facts are not shown in the proper context. Now, please, Milords, may kindly note the first point. To prevent the accused from causing disappearance of evidence. That is why they say my arrest is necessitated. The first point is the evidence having bearing on the case and pending search and collection pertains to plethora of evidences involving tax invoices and so on and so forth. So this is with regard to Kalyani, Milords. Now, Milords, this is as far as a month back. Whatever they wanted to collect, they could have, they should have collected by now. So now today my custody is not required. Even further, so Milords, I'll go a little further. Please come to page 21 of my bail application. So, Milords, this factory was there. This was handed over to Sachin Kumar on 1/12/2022. The FIR is registered on 16/12/2022. Milords, how can I be made responsible for whatever happens beyond post the period of 1/12/2022? That is why the judgment of Sunil Bharti Mittal, that I am not in the power and possession with regard to this mill. I have handed over to one gentleman, Sachin Kumar. How can today I be made responsible? Either the case investigation or the case diary shows that yes, this person is still running and so forth, that finding has to come. That is not on their own record. That is my respectful submission. Merely because you say that you are the managing director and there are documents to be collected with regard to this company, I cannot be kept behind bars. Now, Milords, may please come to serial number 2 at page 40 again.
Yes.
Now 2 and 3, Milords. There are 2 3s. There is at page 40 and page 41. The numbering is incorrect, Milords, to my respectful submission. So page 40, point number 2, and page 41, point number 3. Both are interlinked. Now please, Milords, may see the accused person deposed in statement under 161. Milords, firstly, 161 of an accused. Can that be made basis for his arrest? Further, and registered manifest in procuring so and Jagdish Soni, a former associate of his, on whom accused person has assaulted on 4 December. Now, Milords, may please see at page 40 only, upstairs, over the top where cases are mentioned. Shillong PS 36 under 506 Shillong. Then Shillong PS
Page 40.
Page 40 only, Milords. Somewhere at the top, starting from serial number 1.
Yes.
Then subclause 1 and 2. They mention with regard to 2 cases, 36 and 37. Milords, this is the basis on which my bail is rejected. 36 is a bailable offence. 37, I am on anticipatory bail. And Milords, what they concede is, I have registered a counter case which is FIR 38. That is why the law of cross cases. It has to be cross. When there are cross cases, they say I assaulted my associate. I say he tried to forcefully take possession. That has to be tried by the court. Truth has to come out whether he assaulted or I assaulted him. That can't be the basis for not denying my bail, Milords. By the end of the day, Milords, there is a counter version by me which is duly registered as an FIR. Which is, Milords, that is FIR number 38. Which is at page 47.
Page 47.
Yes, Milords.
This is the answer. This is an order.
Yeah, I'm so sorry, Milords. It will be at 40. This is the order in which, this is the FIR number 37 in which I am granted bail. The court below says that you are accused in FIR 37, but the court does not appreciate that I have been granted bail. Now please see page 49, Milords. This is the cross FIR which I am making reference of. At page 50, FIR against Rishi Agarwal, Jaggu Soni, which is, Milord, the same person, Jagdish Soni.
Yes.
So when, and an FIR is also registered. So when there are counter cases, How can that be made basis for my denial of bail, my lords? Now please come back to page 40 again, my lords.
Yes.
Point number 3, my lords. Page 40, my lords.
Yes.
My lords, now please see the accused person deposed in his statement under 161 that the activity in question involves multiple coal suppliers from Assam and their truck who was transported from so and so to his factory, which if true as claimed. My lords may kindly note which if true. If it is not true, then what? Why I should be behind bars? The investigation agency is going on a speculation. If it is true, then it is so. You can't arrest people on speculation, and that too for the offences which are less than 7 years. And please bear in mind, my lords, I have joined investigation twice whenever they have called me. Merely because you want me to say something which I am not willing to say, you have arrested me. Now, my lords, may kindly see what is my case. Please come to page 35. I am saying I am also a whistleblower. I am telling the DGP, the Chief Secretary, with regard to illegal mining. I have annexed photographs also. Page my lords, 25.
35?
25, my lords.
Yes.
So, this is, my lords, I am writing to them. Please see, it's an email from yudig8@gmail.com. So, I am writing, I am annexing photographs. Just because I try to blow a whistle against people who are doing illegal mining, they have arrested me. What is the action taken by the state? State is supposed to act in a fair manner. They say there is an illegal mining or there are 57 mines and so forth going on. What action has been taken against the other people? There is nothing. There is pick and choose attitude by the state agency, which cannot be accepted in my submission, lords. That can't be the basis. The state has to act in a fair manner. They can't say that just because I don't like you, I will arrest you.
Lordship, kindly come to again page 25. Can you see, note the date, your Lordship? Kindly note the date. This is only after raid had been conducted and the order passed by this honorable court, your Lordship. Then, Lordship,
just you have done?
No, done? Lords, just one judgment. Then, Lords, I'll conclude, Lords. I am very sorry, Lords. This is... Sir.
What is that judgment?
Now, this, my lords, if may recall, my lords, I made a request that there is an unfair investigation. That's why I said that the CDR is, the CCTVs have to be here. I am requesting, my lords, to please come to para 16 of this judgment.
Just one. Para 16?
Yes, my lords.
Yes.
Sorry, my lords, I'll read from 15 onwards. Another point which arises in consideration is the discriminatory treatment of the petitioner co-accused Ankur Chawla, who is named in the FIR. The session judge has rejected this plea of the petitioner by observing that it is not for this court to say as to when and which accused person is to be arrested. This is true that the investigation and so forth, my lords, I'll leave it at that. But please see para 16. Coming back to the facts of the case, the FIR has been registered against not only the petitioner but also against co-accused Manoj, who is in custody, and one Ankur Chawla, who is a legal practitioner representing a group of shareholders headed by so, which is under litigation. The FIR is against all three persons, has been registered, and the basis source information which their conspiracy to commit the offence under various provisions of PCA Act, yet no action has been taken against the said person by the investigation on the ground that the investigation agency has recorded his statement as and when anything incriminating is brought on record, he will be treated in the same manner. the court fails to understand as to what other evidence ought to have been there before any action could have been taken against the co-accused named in the FIR, who had prima facie been responsible for arranging the funds and the activity in participating of giving the bribe. So I am not even named in the FIR. FIR is registered in somewhere in December, my lords. I am called in May. I am cooperating. What is the material? The material which is there for my arrest is at page 40. That is only to be seen whether it was a justifiable material or not, or even if it was justifiable, whether my incarceration is to be further behind bars in view of this evidence, my lords. I have been under custody for more than 35 days today. And I am saying, my lord, the state has a pick and choose attitude. There is indiscrimination on behalf of the state.
Yes, that will be.
If Lordship kindly come to page 45 of the bail application, Your Lordship. This is the order passed by the learned session judge, Your Lordship, rejecting the bail, Your Lordship. It's a well written order, Your Lordship. Page 45, Your Lordship.
Yes.
Lordship, the learned special judge has gone through the case diary. He has come to a finding. It's a recent finding, Your Lordship. It's a recent finding.
Page 45.
Lordship, yes, of the bail application, Your Lordship.
You are referring to which paragraph?
Lordship, that is it should be the open hearing, Your Lordship. The finding of the learned Lordship has got it. Upon hearing all the parties and on perusal of the original CD and the report, it is observed that so and so, Your Lordship.
This order is not in question here.
Yes, Your Lordship. But the finding of this is the finding. What I mean to submit, Your Lordship, this is the finding of the learned special judge, MMDR Act, Your Lordship, justifying the rejection of the bail application filed by the bail applicant. That's all.
So I've heard the parties.
Yes,
I'll produce the case diary and I'll pass in the orders.
Please, my lord. Deeply obliged, my lord.
Apply, Your Lordship.
Item number 2.
Lordship, here in this case, Lordship was pleased to pass an order stating the petitioner to come and come before us along with their records, which they have not complied.
Sorry, my lord, it is not a correct factual position. We have gone there, my lord. They have given a list that this much amount we should pay. Now, my lord, what happened? We have also produced the challan that the amount they was claiming was already paid, my lord. That is a claim and counterclaim. That is what I am requesting, my lord, before this honorable court. Let them file an affidavit, my lord, and we will also produce the record that what amount we have already paid. If the amount is already paid, I am saying if the amount is already paid, my lord, there is no question of paying double, my lord. Let them file an affidavit, how much is their claim. Then we will check, my lord, with our challan, because it's all bank transaction, my lord. We cannot manipulate anything. Let them file an affidavit, my lord.
Lordship, we will be filing the affidavit, but Lordship, on 28, last date, when the miscase was disposed of, Lordship, as per the order of the miscase, Lordship, it goes, Lordship, before 28, they came forward. Thereafter, your Lordship was pleased to defreeze the account, Lordship. But with the direction, Lordship, that they will come forward again with their to settle this matter. But thereafter, after prior to 28 they came, thereafter they did not, Lordship. Now the thing is that when the account was defreezed, the communication with them is totally stopped. They are not communicating anymore. Now they are waiting for me to file the affidavit. They are also, Lordship, because it is an admitted fact that, Lordship, they are liable to pay. It is an admitted fact.
That is what we are making a request, my lord. Let them bring in record.
When there's a clear direction by this court for you to...
We have gone, my lord. My lord, we have gone.
That is prior to 28, Lordship. I'm agreeing that prior to 28.
Can she allow me to submit?
When was the order passed?
My lord,
28.
on 28, last order was passed. My lord, may kindly take into note, they have given us an address of Laimukra. We went and searched the office is in Barik. My lord, may kindly see the conduct. She was here, my lord, she could have pointed out that the office has changed. It was we, my lord, 3 days it took time for us to go and search the office. We have gone, my lord. On last occasion, my lord, we have gone. They have given us the details that this much amount we should pay. We have also shown our counterclaim, my lord. Then, my lord, they said, okay, fine, we'll call you. They have never communicated to us anything, my lord. If they have told us, my lord, that they will call us, my lord, it was their duty to call us. Even then, my lord, I'm not saying on that. I'm not into that point also. I'm not placing that argument also, my lord. The base on which they are claiming that this much amount of money we should pay, my lord, they should just produce that, my lord, before this honorable court by way of an affidavit. That will be a matter of record, my lord. And if we can produce a counterclaim, my lord, that we have already paid, my lord, then we are not required to pay. That will simplify the matter. Why they are hitting around the bush, my lord? Let them file an affidavit, bring in record that this much amount it is due. They are not giving us anything clear cut, my lord. How can we pay, my lord, if there is any claim? They should be very clear, my lord. Their consciences are not clear, my lord. That much I can submit, my lord.
Lordship, we have on prior to 28th, Lordship, when the meeting was held, we have given them the list that this is the amount you are supposed to, according to the which they have not enclosed in this petition, Lordship, which they have not enclosed. We have given them that the list the date wise, that this month this is your payable, this month this is your payable. The delay, because this is under section 14b under section 7q 14b, Lordship. So we are on delay part. So, Lordship, if there is, according to the challans, whatever they have submitted, it is on delay. Lordship, we have also pressed that we have also played after the Lordship's order, Lordship. It was 1 week. Within 1 week, they are supposed to. It is clear, Lordship, according to the Lordship order, it is clear that within 1 week they are supposed to come.
See,
they themselves, they say that we will call you.
He is saying that you have given a wrong address, number one.
A wrong address, Lordship.
Eventually,
we got the place.
He got the correct address. He has met you.
Lordship, it is prior to 28, Lordship.
Prior to 28 and
prior
on that,
to 28, Lordship.
let me please submit, this is my case. My lord, prior to that, before 28, they have informed us whenever it is required, we will inform you. You cross-check those documents with your record. We are cross-checking it, my lord. And they said that they will inform us when to go.
See, Mr. D,
yes, my
you
lord.
Look at the order of
my lord.
28.
My lord.
Look at the last 2 lines. What does it say?
Yes, my lord. I have seen, my lord.
As far as the next meeting is concerned.
Yes, my lord.
So, the meeting is supposed to be after the 28th.
My lord is totally correct, my lord. Here, on the last occasion, prior to 28, they informed us, we'll call you. You cross-check.
See, Mr. Dev, we are not on that.
My lord.
Whatever they say, that is already gone.
My lord.
That every action taken will be superseded by this order.
My lord, my lord.
So thereafter,
my lord, if that is the case, if this honorable court wants us to go again, my lord, we'll
it's
go.
not a question of what, Mr. D. It has been agreed to by the parties, and you have violated that agreement.
Yes, no, my lord, we will go. If it was because of the confusion they have created, my lord, they said we'll call you.
You have created confusion,
no, my lord. We have gone.
You have not gone.
My lord.
Now you are talking about an event which happened prior to 28.
We'll go, my lord. That much I can assure, my lord, this honorable court, that we will go. Since there is an order, we'll comply with the court order.
Go and meet them tomorrow.
Tomorrow may not be
meet them tomorrow, otherwise
Monday will go, my lord.
This matter will be called up on Monday.
Monday, my lord.
Yeah, no, you go and meet them tomorrow.
Tomorrow?
Monday this matter will be taken.
Let the matter come up Tuesday. Let them go tomorrow, Lordship. Monday I have one matter in Guwahati. So let the matter come up Tuesday.
We will go on Monday, my lord. Tuesday we will report to this honorable court, my lord. Monday will go.
So Monday.
My lord.
Lordship, on entry appearance for us.
Who is respondent for? As far as your role is concerned, nothing much.
But because we've received notice, so
only
Ms. Angela, letter counsel, has entered appearance on behalf of the respondent number 4. Upon hearing the parties, it transpired that the order dated 28/6/2023 has not been complied with by the petitioner, inasmuch as the petitioner's representative have not met the respondent's EPFO representative to sort out any misunderstanding or
Differences, my lord.
differences, if at all. Without going to the in view thereof, this court would grant one more opportunity for the parties to meet and to report to this court on the outcome of the said meeting. The parties are directed to meet on
24th, my lord.
24th, and to file a report on the next date fix. List this matter on 26.
Right.
Item number 3.
What are these documents related to?
Your Lordship, these documents which was availed from the archives of the State Government of Assam. They are under public domain, and it very much relates with the issue in connection with this case, Your Lordship. Your Lordship, may I kindly refer which the Annexure 2, Annexure B, which I'm relying upon in my affidavit, Your Lordship.
Annexure B.
Yes, Your Lordship.
Page?
Page number 8. No, Your Lordship, in my affidavit in opposition that I have filed.
When have you filed the?
Since the 23rd of July 2021, Your Lordship. Page 8, Your Lordship.
Just a moment.
Annexure B.
Yes.
Lordship, the document that I have proposed and submitted along with Your Lordship, they are in conformity with the Annexure B, Lordship. We can refer to the document, Your Lordship, which I have.
These are the allottees.
Yes, Your Lordship.
You are referring to these allottees.
Yes, Your Lordship. So eventually, Your Lordship, it falls under public domain ever since the time when the government of Assam then had issued all relevant document with respect to the allotment of plots at RR colony, Your Lordship. So, Lordship, the document that I have annexed along with the document, Your Lordship, may kindly refer to page 56, Your Lordship. May kindly refer to serial number 1298. Page 50. It's page 52.
It's not paginated, the copies that have been served with is not paginated.
You should have done so.
Yes, I'll let you know. But it's at page 52, your document.
Just the below
Pages here.
52.
Page 52.
So what is this 1298?
1298, Your Lordship. It's in relation to the Annexure B, Your Lordship, which I have relied, which is in respect with plot 164. It confirms of the allotment, Your Lordship, that was made.
So 164 was initially allotted to Shri Nagendra Kumar Chaudhary.
Yes, Your Lordship.
Thereafter, it was allotted to you.
No, Your Lordship. I'm referring to this document, Your Lordship, in conformity which was in relation to the Annexure B, Lordship. Because this is an archival document which is under public domain now, Lordship. Your Lordship, I can refer to page number 12 of my affidavit in opposition.
Yes.
Serial number 164, Your Lordship.
Yes.
On the right hand side, Your Lordship, is the plot number. It confirms, Your Lordship, with the records available which I have obtained, Your Lordship, from.
See, if there is no dispute as regard this list that you have produced, then there's nothing to it.
Yes, Your Lordship, but the entire issue related here with also, Your Lordship, is in connection with the resumption of the plot which they have raised. The entire matter, Your Lordship, it comes with the annexure with the annexure number 1 which they have relied on.
See, what you have done is you have annexed this list of allottees.
Yes.
Correspondingly, you have also issued some documents which relates to the same.
Yes, Your Lordship.
Which,
and Your Lordship,
which, if there is no dispute at all.
No, Your Lordship, my contention here, Your Lordship, in respect to the plot in connection with this matter, Your Lordship, plot 267. It's nowhere mentioned, and as per the archival documents, it's nowhere, and it has not been allotted to anyone.
Okay.
Ever since that period, since issuance of the notice, which the petitioner has been relying as annexure number 1, since 1959, Your Lordship. Because the entire issue and matter in controversy here, Your Lordship, is with respect to the allotment which they have claimed for.
Okay.
So now they are asking possession now, which, Lordship, it doesn't have any connection there with, Your Lordship. So my main contention of producing this document is for proper adjudication of the matter, that ever since this period, which the record falls under public domain, it's in conformity with the document which I have annexed, and nowhere is connected with the plot which they have claimed so that they have been allotted and taken possession of, Lordship.
Yes, Mr. Thapa?
No, my lord, here that's the very case where, my lord, what my learned friend has just said, my lord, that is exactly our cases. Here, my lord, after the land was allotted to us, my lord, it is a matter of record that we had shifted our, for my lord, employment purpose, we were in Arunachal Pradesh, my grandfather. Now, apparently, my lord, before resuming those plot of land, my lord, no notices was ever issued to me. That's our case. Now, my lord, if a land has been allotted to me after following a due process of law, even to undo that or to resume the land, my lord, certain procedure has to be followed. Our contention is no such notices were ever issued to us. So the question of resuming is, my lord.
But when we're talking about allotment, if you say that you have been allotted land, so if we go by these documents, your name doesn't figure anywhere.
It is not there, my lord. But at least the state government would have to show that some efforts were being made. The initial allotment was to us. My lord, here the only problem is, my lord, it's not paginated. My lord, in terms of your lordship, last order, a liberty was given to us to file a rejoinder if required.
My lord, we would like to cause a reply because, my lord, here I have not gone through this document properly, my lord. In terms of your lordship's last order, my lord, kindly grant us some time to go through this document and file a rejoinder if necessary, my lord. And my learned friend, of course, this has to be paginated as per what he has filed in court, and it has to be tallied also.
You got the complete set, isn't it?
I have got the complete set, but I don't know, my lord, whether it is complete in totality or not.
So he starts, I think, page 1 would...
Pagination, my lord, it's not paginated, so I don't know if something is missing in between. Then I
missing. There are 77 pages of work along with the affidavit.
Anyway,
I'll tell him,
that you can do, or you can
I'll hand it over to him. Let him paginate and send it, give it back to us.
To clarify on the matter, Your Lordship, initially, whatever notice that has been issued by the then government of Assam, it confirms with the entire document that I'm relying upon. Your Lordship, on the issue of law, Your Lordship, which I would many a time would have, with due respect for the court, has been praying for, because with the matter related to revenue matters, there are various judgment which has been delivered and pronounced by the Honorable Supreme Court, Your Lordship. And there's one question of law, Your Lordship, which was decided and answered by the Supreme Court in the second appeal. This is in matter with respect to possession.
So we'll not go into that. We'll not go into that at this juncture. We'll have to give him an opportunity to file a rejoinder to this. We'll take up the matter on next week then.
No.
Respondent number. You are respondent 4.
Number 4, yes.
Respondent 4 has filed an additional affidavit, an affidavit bringing on record certain documents. The petitioner, speaking through its counsel, has submitted that he may be allowed to file a rejoinder if the learned counsel for the petitioner has submitted that he may be allowed to file a rejoinder to the same if so advised, if so instructed. This being the case, this matter is adjourned for the day to allow the petitioner to take steps if so advised. List this matter up to 1 week.
Item number 12.
Yes, where were we?
I had completed my arguments.
Yeah.
They were to respond if they had anything to respond. I've already supplied a copy of the compilation.
That will be on the issue of maintainability.
Maintainability minutes. Now, in the meantime, what's happened is Mr. Sangma, who had sought to interject on the last date.
Has you filed an application?
We received a copy. I'm not sure if it's filed yet.
The matter was not listed today, my lord. Actually, we have informed the registry that the matter is listed today.
Oh, it's
It
not.
was not listed today, my lord.
What do we do?
I have no objection to this. If they want to interfere and delay it, I think the best course is I've already served them a copy. Knowing well that they'll want to be implemented as parties, I've served them a copy of my civil revision application. As and when this application comes up, either today or tomorrow, if it's available, lordships may make them parties.
Seen Miss case number 10 of 2023 filed by the applicants therein with a prayer for for impletement or oblique adding such applicants as party respondents in the main case, that is CRP number 36 of 2022. So you have no objection? What about the others? The petitioner appearing through the petitioner. The opposite party number 1 and 2. You are also representing number 2.
Lordship.
Opposite party number 2. You are also there.
I'm for the state, my lords. For the
State,
for the revision.
for the tax. Who's paying for tax?
For me, my lords. 1 and 2.
That's
Petitioner number 1 and 2.
That's what I said.
Lordship.
The opposite party number 1 and 2. Oblique petitioner in the main case, appearing through Mr. S.N.
36.
Then it, your senior GA.
Lordship.
Then the senior GA has no objection to this petition, has accepted notice of this petition. Similarly, counsel for respondent 3, for opposite party number 3 herein, has also accepted notice and has received copy of this petition. In brief, all the parties involved, particularly the opposite parties, have no objection to the prayer made in this petition and has considered that the applicants herein may be added as party respondents in the main case. Accordingly, the prayer made in this missed case is allowed. Petition disposed of.
Lordship, just one thing. Registry may be directed to make that entry in the
that
cost.
I will pass in
Lordship.
the main
Lordship.
case.
Lordship.
My application for intervention and infringement is also pending, my lord. Which, my lord, respondents are not yet not filed the objection, my lord. It's been pending for many.
Oh, you also?
Yes, my lord. It's there in the cause list, my lord. This case number 5 of 2000.
I think the respondents cannot really question who should be a party. It is my call.
Yes.
I have no difficulty. But they had on the earlier occasion said that since maintainability is an issue, let that be heard first and then their application be considered. I don't think that is the correct way. Somebody else should be considered, somebody else should be left out.
Now
They may be also made parties. I have no objection to that, my lord.
So we'll take up that case and pass a similar order.
Lordship.
Number 5.
So same order, Mr. Same order should change nothing to you. Party's name, category miss case number 5 of 2023. Main case no. In view of the fact that this court has allowed the proper and necessary parties, this court has allowed addition of party respondents to these proceedings by related orders in MC CRP number 10 of 2023 as well as in MC CRP number 5 of 2023, wherein the applicants therein have been allowed to be read as respondents in these proceedings. Therefore, the registry is directed to make necessary correction in the cause title. This matter will appear 1 week hence.
So for whatever arguments they would like to respond, and also the newly added party respondent, if he wishes to make any arguments, let it be concluded on the next day itself.
Exactly. Okay, 1 week hence for final for argument by the advancement of argument by the respondents. So one.
Second call from supplementary process, item number 1.
This is our application was tagged with item number 14. That may also come up after a week. Sorry. So it's 12 and 14 are tagged together. Lordships have passed these orders in item number 14.
In item number 14?
14. And 12 is also tagged together.
So 12 will just pass a simple order that matter will come. 12 matter will come up after 1 week.
1 week. Highly obliged.
Wait, please, Your Lordship. Lordship, since learned TSJ is still on legs, can this matter be posted on?
Still on legs where? Which court?
Before learned.
We have no objection, Your Lordship.
Is the court going on?
Lordship.
Nowadays you cannot fool the court. You look at the display board.
Lordship, we have no objection. It's better that we...
We'll hear the matter altogether, Mr.
Lordship, senior counsel by next week.
So, when?
By next week, Lordship.
Next week?
Next week, Lordship. We have no objection, Your Lordship.
On pre-made by the parties, list this matter for final hearing after 1 week.
Like Lordship.